them as a person?
I made them in my role as an advocate.
Do you mean them as a person? I'm not asking you in your role as an advocate. Do you believe that if you're against white supremacy, you have to be against voter ID laws?
Senator, in my role as an advocate, I have...
Ma'am, I'm not asking you about this. It wasn't a case.
Before today's story begins, ask yourself one question. If someone is seeking a lifetime appointment as a federal judge, shouldn't they be willing to tell the American people what they actually believe? That question took center stage during a tense Senate confirmation hearing when Senator John Kennedy confronted two of former President Biden's judicial nominees over controversial public statements they had made before their nominations. But instead of simple yes or no answers, the hearing quickly turned into a back and forth over advocacy, personal beliefs, and judicial impartiality. Kennedy insisted he wasn't asking what the nominees argued as lawyers representing clients. He wanted to know whether they personally stood by those statements today. The nominees repeatedly pointed to their former roles as advocates, while Kennedy argued that Americans deserve greater transparency from individuals who may serve on the federal bench for decades. In this breakdown, we'll walk through the key moments from that exchange, examine the questions raised about judicial independence and accountability, and let you decide whether the nominees answered the Senate's concerns. Stay with us until the end, because Kennedy's closing remarks became one of the most talked about moments of the hearing.
Ms. Merrill, I'm looking at an article you wrote in The Breach in 2017. You said, I'm going to quote, "It's inconsistent to denounce white supremacy but not repudiate voter ID laws." Did you say that?
Thank you for the questions, Senator.
You're welcome.
I believe that was an interview I gave in the days after Charlottesville,
Right.
and I believe those statements were it was in my role as an advocate regarding my work representing voters in Alabama challenging.
So you didn't mean them as a person?
I made them in my role as an advocate.
Do you mean them as a person? I'm not asking you in your role as an advocate. Do you believe that if you're against white supremacy, you have to be against voter ID laws?
Senator, in my role as an advocate, I have...
Ma'am, I'm not asking you about this. It wasn't the case. I'm asking you what you believe. And I don't appreciate you dodging my question. Now, this is a serious position you've been nominated for. Do you believe that someone who is against white supremacy also has to be against voter ID laws?
Senator, no. The Supreme Court has held that photo ID...
What do you believe?
I believe that the Supreme Court has held...
What do you believe personally?
I believe that photo ID laws have been held to be constitutional.
Do you think voter ID laws are appropriate or inappropriate?
I believe those are questions that election officials...
Do you believe that voter ID laws are appropriate or inappropriate?
I believe that photo ID laws have been held to be constitutional. I believe there are cases in which they are...
What do you believe?
I believe there are cases in which they are
What
appropriate.
do you believe?
I also believe there are cases
What do you
in
believe?
which they can...
What do you believe? Do you
Senator,
believe?
let her answer, please.
I'm trying to. We both know what's going on, Mr. Chairman.
Let her complete the sentence.
Well, let me do my own questioning, Mr. Chairman. I appreciate your help, Professor. Do you believe that voter ID's laws are appropriate or not?
I believe there are circumstances where photo ID laws can be constitutionally implemented. And I believe that the Supreme Court has also held that there are circumstances when they would not be constitutionally permitted.
Okay. All right. Ms. Chaudhry. Am I saying your name right?
It is Chaudhry.
Chaudhry. Thank you for correcting me.
Thank you.
In 2015, you were on a panel at Princeton University. You said that the killing of unarmed black men by police happens every day in America. Did you say that?
Senator, I don't recall a statement, but it is something I may have said in that context.
You think it happens every single day?
Senator, I believe in that statement, I was making a comment in my role as an advocate, and I was engaging in rhetorical advocacy, which...
But do you believe that police officers kill unarmed black men every day in America?
Senator, I believe the killing of unarmed citizens by law enforcement is tragic, and I believe in that instance
I think it's tragic too, but do you believe, this is a really simple question, Counselor, do you believe that cops kill unarmed black men in America every single day? You said it at Princeton.
Senator, I said it in my role as an advocate.
Oh, okay. You didn't mean it.
Senator, I said it in my role as an advocate to make a rhetorical point.
So when you say something that's incorrect, it's okay to excuse it by saying, oh, I was being an advocate? What do you believe? Do you personally believe that cops kill unarmed black men every single day in America?
Senator, I believe law enforcement have an important and challenging job in this country.
That's not what you said, though, Counselor.
Senator, I say before you here today that I do believe law enforcement have a difficult and challenging job, and I also understand the difference
I just think that's an extraordinary statement to make with no data to back up. None whatsoever. There's no basis for you saying that. And you knew it then and you know it now. How can one possibly believe that you're going to be unbiased on the federal bench?
Senator, I believe my record shows that I have worked collaboratively with law enforcement in Boston, Chicago, Mississippi, and Milwaukee to solve complex problems to promote constitutional, effective, and safe
Your record
policing.
shows that you believe cops are guilty until proven innocent. Your record shows that if a cop, if a cop shoots a criminal, it's the cop's fault. And if a criminal shoots a cop, it's the gun's fault. I've read your record. Ms. Murrell, and I don't appreciate you not answering the question straight up. I would respect you a lot more if you'd just tell us what you believe and not try to hide it.
At this stage of the hearing, the discussion moves beyond a single controversial quote and into a much broader constitutional question. What should senators expect from judicial nominees during the confirmation process? Every federal judge serves with extraordinary authority. Once confirmed, many will remain on the bench for decades, making decisions that can shape everything from voting rights and criminal justice to free speech and constitutional interpretation. That's why confirmation hearings are designed not only to review a nominee's legal qualifications, but also to examine whether they can apply the law fairly and impartially. Throughout this exchange, Senator Kennedy repeatedly drew a distinction between legal advocacy and personal conviction. He acknowledged that lawyers frequently advance arguments on behalf of clients, even when those arguments don't necessarily reflect their own beliefs. But his central point remained unchanged. Now that the nominee was seeking a lifetime judicial appointment, he believed the Senate, and the American public, deserved to know where she personally stood. The nominee, however, approached the questions differently. Rather than discussing her individual views, she consistently pointed to Supreme Court precedent and the constitutional framework governing voter identification laws. That response reflected a common practice among judicial nominees, who often avoid expressing opinions on politically sensitive issues out of concern that doing so could call their future impartiality into question. As viewers watched the exchange unfold, two very different philosophies became apparent. One side argued that transparency requires direct answers about deeply consequential public statements. The other suggested that judicial independence is best demonstrated by focusing on the law rather than personal beliefs. That tension lies at the heart of many modern confirmation hearings. It's not always about reaching agreement. It is about defining what the Senate should reasonably expect from those entrusted with interpreting the Constitution. What do you think? Should nominees clearly explain their personal beliefs when questioned by senators, or is it more appropriate for them to avoid personal opinions and rely solely on the law? Share your perspective respectfully in the comments below. As this confirmation hearing came to a close, Senator Kennedy left the committee with one unmistakable message. In his view, the issue was never simply about voter ID laws or comments regarding policing. It was about candor. He argued that nominees asking for one of the most powerful and enduring positions in the American legal system should be willing to answer straightforward questions with equally straightforward answers. The nominees, meanwhile, maintained a different approach. Throughout the hearing, they emphasized that many of the statements Kennedy cited were made while serving as advocates representing clients or advancing legal arguments in professional settings. Rather than revisiting those remarks as personal beliefs, they repeatedly directed the discussion toward constitutional principles, judicial ethics, and established legal precedent. That difference in approach is what made this hearing resonate far beyond the Senate chamber. To some observers, Kennedy's questioning reflected the Senate's constitutional duty to thoroughly examine the judgment and philosophy of judicial nominees before granting them lifetime appointments. Others viewed the nominees' restraint as consistent with long-standing confirmation practices, where future judges avoid expressing personal views on politically charged issues to preserve the appearance of impartiality. Regardless of where you stand, one thing is difficult to dispute. Moments like these shape public confidence in the judicial confirmation process. Americans expect judges to apply the law fairly, independently, and without political favoritism. Confirmation hearings provide one of the few opportunities for the public to evaluate how nominees respond under intense scrutiny before they ever take the bench. The debate over transparency, advocacy, and judicial independence is likely to continue well beyond this hearing, especially as future nominees face similar questions from lawmakers on both sides of the aisle. Now we want to hear from you. Do you believe judicial nominees should directly explain their personal beliefs during Senate confirmation hearings? Or should their advocacy work and legal arguments be considered separately from their qualifications to serve as judges? Leave your thoughts in the comments below. If you enjoyed this balanced breakdown of one of the Senate's most closely watched confirmation hearings, be sure to like this video, subscribe to the channel, and turn on notifications so you never miss our in-depth coverage of Congress, the courts, and the political stories shaping America today.